criminal procedure. This class is going to be a bit short. I had originally intended to go more in depth, but I realized that this is, it would be a bit too broad in scope, and also the terminology, which I always say is the main point of the course, was very similar. So you also you have the defendant, you have the prosecution. There are some differences between the systems, and we'll explain those. But I think basically that the American criminal procedure that we learn, the vocabulary can be used here in the UK as well. You have different rules for England and Wales, and this is a general idea in English law that Scotland is sort of different. So England and Wales, you have the investigation and the charging. Usually an aspect that I can tell you is different is in the other common law countries outside the United States, if they are part of the Commonwealth, so they are part of the British monarchy sort of, because in Canada, Australia, New Zealand, the United Kingdom, and many island countries such as Tuvalu, Jamaica, I believe they're trying to become a republic now, but previously, they are all sort of part of the Commonwealth, so they all have the British monarch as the head of state. So in those countries, it's common to refer to the prosecution as the Crown. The Crown would be in charge of prosecuting criminal offences, but the person being prosecuted would still be the defendant. And the procedure in the UK, at least, is also jury trials. The magistrate's court, the Court of Appeals in the United Kingdom. I did mention this. You refer to the people in the Court of Appeals as Lords of Justice, even though they're not members of the House of Lords, and do issue a ruling. But you still, you have the jury trials for criminal cases in the UK. There's some talk of changing that, but mostly that has remained the same. The guilty and not guilty plea, this comes from the UK, so it works the same way as the United States. So before the trial starts, you have to submit a plea. As a defendant, you have to say, I plead guilty or I plead not guilty. Trial itself, it's a jury trial, so all the things we discussed still apply. Cross-examination, testifying, you have to prove the defendant's guilt beyond a reasonable doubt. Obviously, you're not going to say I plead the Fifth, because the Fifth Amendment is not going to apply, but you still have many of the same protections. The sentencing is the same thing. The difference is that the UK doesn't really do death penalties, so it's more life sentences at most. Obviously, legal representation. This is an important aspect that in terms of vocabulary differences. In the United Kingdom, usually when you're being represented by a lawyer in court, that person is referred to as a barrister. So the barrister is the person who represents you in court, whereas the solicitor represents you sort of outside of court or in some lower courts. But the person in the courts is usually called a barrister. Another aspect that is perhaps peculiar is that if you become accomplished enough and well accomplished and recognized as an attorney in the UK, you become King's Counsel or Queen's Counsel, and that's just sort of an elite classification of lawyers, which is governed. You have to pass the bar in order to become a lawyer or a barrister or solicitor in the UK as well. And if you become King's Counsel, that is just a form of recognition, saying, well, you've become a very accomplished attorney or a very accomplished barrister or solicitor. Obviously, that's going to depend if it's a king or queen that's the monarch. So before it was Queen's Counsel, right now it's King's Counsel. Like I said, being in a common law jurisdiction, you have an adversarial process, you don't have an inquisitorial process, it's a jury trial. So, you have to have jury proceedings and the parties have to cooperate with each other, and you cannot use hearsay evidence. So really a lot of the rules are the same and the vocabulary is the same, which is why I'm keeping this limited just to highlight a few differences. This is something interesting. I didn't really see anyone talking about this in American law, and this came up a lot when I was researching English criminal procedure, which is a statement made in the presence of the accused. So if someone says something and you're in the same room, that can be used as evidence against you. Basically, what you're saying is, well, I said, I was talking to him and I told him about it and he didn't seem surprised. So that's something that can be used against you, and that's going to follow specific guidelines. So for instance, probative use or prejudicial use. So if you say something that could be considered a hearsay use, and hearsay, we discussed that in the other class about American criminal procedure, that cannot be used as evidence. If you hear rumors about something and you say that in your deposition, that cannot be used as evidence, that's hearsay. If you use that sentence in court to infer something from the accused's response in court, then that is not a hearsay evidence. So it's interesting to highlight that jury proceedings are, theatrical, and there really is an element of performance to it. Also, the Police and Criminal Evidence Act of 1984, so they're not relying on the Fourth Amendment and Mapp versus Ohio. There's basically this act that was enacted in 1984, which regulates the illegal evidence and unconstitutional, not really unconstitutional. We discussed this in the English Constitution class, but illegal or evidence obtained illegally. So it's a bit different from Mapp versus Ohio. They don't really have exclusionary rule. They have, the courts, they have more discretion. This is just a general rule that comes from English history, really, where the courts have had historically a lot of discretion because, there's this parliamentary supremacy, so really anything they do can really effectively be overridden. So it doesn't matter how much discretion they have because Parliament will always have the final say. So when it comes to illegal evidence in the United Kingdom, that is a big difference. The courts do have more discretion in allowing it to be used or not. This is very interesting here because dishonesty is itself primarily a jury concept. So this is something and this is an extremely recent case. So it highlights how jury trials work. You don't have to provide an extremely ample definition of what is dishonest behavior in the criminal statute because the jury is going to decide. You're basically going to ask the jury, well, do the jurors think that this is dishonest behavior? And they're going to say yes or no, this really is how the entire the idea of a jury trial is, and this sort of is the foundation of a common law system. So you don't have to have complicated theories of what is and isn't dishonest, because ultimately the jury is going to decide on that. So a little bit of case law here, R versus Christie, that was about the statements made in the presence of the defendant. Ivy versus Genting, that I just quoted that. And the other stuff here, it's difficult to gain access to these decisions. I had a hard time myself finding these decisions. The same warnings that I do for the American cases apply. This is just the beginning, and I think the English judiciary system is very strange to us because it's very old and it has all these leftover institutions from the medieval period and from the older periods of time. So I would recommend really going in depth with both books and case law. So really here we're just trying to familiarize ourselves with a few differences in case that ever comes up, especially if that comes up when we're analyzing case law from a different country, because sometimes English case law does come up in American case law, especially from the Supreme Court. Like I said, they will always quote old English case law in order to justify some decisions. Yeah, I think this is an even more short and superficial summary of English case law than in the American case law that I provided. So I would urge anyone who's interested in English case law to really dig deeper and really try to do their own research on this matter, because it is a bit harder to research. It's not as readily available as American case law. All right, so I'll see you on the next class where we'll discuss some details concerning English civil procedure.